Our group is going to present on X Corp versus World Federation of Advertisers et al., analyzing antitrust and corporate boycott allegations. A presentation will include an introduction, a statement of issues, current status of the case, and then any recent case updates since the initial filing. We'll also go into discussion about monopolies and the use of safety and digital media, and then trade associations and socio-political considerations, and end with our conclusion. Introduction. When does business strategy become illegal? The antitrust battle between X Corp and major advertisers. A case that could redefine corporate power, competition, and digital advertising. Today, I'll introduce X Corp versus World Federation of Advertisers et al., a lawsuit that could significantly impact corporate competition, advertising decisions, and antitrust law. What is Twitter and X Corp? Twitter, founded in 2006, became a key platform for news, engagement, and digital marketing. In October of 2022, Elon Musk acquired Twitter for $44 billion and rebranded it to X Corp. His vision expanded beyond social media into financial services, AI, and a broader super app model. Elon Musk's controversial changes included looser content moderation and reinstated accounts, which led to clashes with advertisers. In response, major advertisers, to name a few, Unilever, Mars, Shell, Nestle, and Lego, pulled ads over brand safety concerns, which Musk called an attack on free speech. The legal issue is, did these advertisers act independently or engage in coordinated anti-competitive actions? We need to look at the Sherman Act and antitrust law, which was enacted in 1890, which prevents monopolies and anti-competitive behavior. Section 1 prohibits agreements or coordinated actions that restrain trade, such as group boycotts. And Section 2 bans monopolization through unfair business practices. So what's at stake here? Advertisers' freedom versus antitrust violations. Advertisers argue that they have the right to control their ad spending, and X Corp claims they coordinated to financially harm the company, violating antitrust laws. And what is the role of industry organizations such as GARM and WFA? Well, WFA and GARM set standards, ad standards, and X Corp alleges that they facilitated an illegal boycott. A ruling against them could reshape industry regulations. And then there's also socio-political considerations and the Musk factor. Musk policies have been controversial, and some advertisers pulled ads over brand safety, while others see it as retaliation. This case highlights the intersection of business politics and corporate influence. And this lawsuit raises critical legal and business questions about corporate power and the limits of decision making. Now let's explore why this case matters and its potential impact on business and legal standards. Now that we've covered the background and legal foundation, let's examine the significance and impact on business, law, and digital advertising. A legal battle over advertising and competition. X Corp claims advertisers colluded to boycott its platform, violating antitrust laws. Defendants argue their ad decisions were independent and based on brand safety and business interest. A ruling for X Corp could set a precedent restricting coordinated ad decisions, and a ruling for advertisers could reinforce corporate autonomy in advertising strategies. Now, why is this case important? It raises concerns over advertisers' influence over digital platforms. A ruling for X Corp could lead to a stricter oversight of industry collaborations. A ruling for advertisers could protect companies' right to control ad placements. Now, the role of industry groups like GARM. GARM is accused of orchestrating an illegal boycott by influencing advertisers. If proven, this case could lead to stricter antitrust regulations on industry groups. Now let's explore the broader legal and business implications. The bigger picture and the business and legal impact. Beyond this case, there are broader legal and business implications that could affect how companies make advertising and strategic decisions in the future. How will this shape the future of antitrust law? It could redefine legal boundaries for corporate advertising decisions. It may lead to stricter regulations on industry-wide collaborations like GARM to prevent anti-competitive behavior. Now, there is a potential impact on digital advertising and social media. It raises concerns about power of large advertisers and their influence over platform revenue. And this could set a legal precedent for how tech and media companies interact with advertisers in the future. Now, corporate strategy moving forward, businesses may need to become more transparent in their advertising decisions to avoid antitrust concerns. Industries like WFA and GARM may face greater scrutiny in their practices, and companies may need to reassess their participation in trade associations to ensure compliance with antitrust laws. This case is not just about X Corp and advertisers. It's about the future of corporate collaboration, business strategy, and legal compliance. The outcome could reshape advertising, antitrust enforcement, and industry group influence for years to come.
There are 3 issues at play with this case. 1. Did the defendants collectively orchestrate a boycott of X Corp in a manner that unlawfully restricted competition and hindered fair trade under the Sherman Act? 2. Is there sufficient evidence to prove that the defendants agreed to withdraw collectively? And 3. Does participation in an industry group, such as GARM, expose companies to liability for coordinated actions that may restrain trade?
The current status of the filing. While X Corp's initial lawsuit in August 2024 targeted the WFA, along with Mars, CVS Health, and Orsted, the case expanded significantly by February 2025. X Corp broadened its allegations to include additional companies it accused of participating in the alleged advertising boycott. These companies include Nestle, Abbott Laboratories, Colgate-Palmolive, Lego, Pinterest, Tyson Foods, and Shell. With such a wide range of companies now implicated, the lawsuit has garnered even more attention. It raises important questions about whether these organizations were acting in their individual interests or if there was indeed coordinated action that unfairly targeted X Corp. To understand the context of this case, it's important to look at GARM itself. Founded in 2019 by the WFA, GARM aimed to ensure that advertising dollars were not inadvertently supporting harmful or illegal content online. In theory, this was a noble objective, helping brands align with their advertising with ethical standards. However, following X Corp's lawsuit, GARM found itself embroiled in legal and financial struggles. By August 2024, it ceased operations, citing depleted resources and financial strain due to the allegations brought by X Corp. The dissolution of GARM has sparked discussions within the advertising industry. Some experts view it as a setback for collective efforts to ensure brand safety and responsibility in digital media. Others see it as an opportunity to reassess and reform industry practices related to content, moderation, and advertising standards. Recent case updates. As of March 8, 2025, the latest developments in X Corp's antitrust lawsuit are as follows. U.S. District Judge Reed O'Connor recused himself from the case without providing a specific reason in August 2024. Reports do indicate that he owns shares in Tesla, another company led by Elon Musk, X Corp's owner. This financial interest raised concerns regarding potential conflicts of interest. In December 2024, Judge Ed Kincaid recused himself from the case without providing a specific reason. Both recusals have contributed to delays in the proceedings. In October 2024, X Corp reached a settlement with Unilever, resulting in the company's removal from the list of defendants. While the specific terms of the settlement have not been publicly disclosed, Unilever's brands have agreed to resume advertising on X Corp's platform. In February 2025, several major advertisers, including Apple, have resumed advertising on X after previously halting their campaigns. Reports indicate that X Corp's executives have exerted pressure on advertising firms to increase spending on the platform. Notably, there were suggestions that a significant merger deal involving Interpublic Group could face challenges if advertising on X did not increase. A group of Democratic senators has called for the Department of Justice and Federal Trade Commission to investigate potential ethical violations by X Corp. The senators allege that Elon Musk may have leveraged his political influence to pressure companies into advertising on the platform, constituting a conflict of interest and potential violations of federal ethical laws. These developments underscore the ongoing complexity of X Corp's antitrust case, highlighting tensions between the company and major advertisers, as well as raising questions about corporate influence and ethical practice in the advertising industry.
We believe this case will have long-standing impacts from a legal perspective, for the entire business world as a whole, and for society from the perspective of the ever-changing media landscape that we all live in. Let's first start by looking at the broader impacts monopolies have in digital advertising. First, one of the biggest concerns is that X argues GARM and its members act as a monopoly. This means they have significant control over advertising and media practices, which can limit competition and create lack of diversity in content. The case has brought public awareness to GARM's power in the advertising world. Before this, many people may not have known the amount of companies and influence that GARM as a single entity has in digital media. This increased awareness and attention could lead to more scrutiny and possibly transparency in the industry. Finally, there's an issue of precedent. If X wins this case, it could impact major platforms like Facebook, TikTok, YouTube, and Spotify. These companies rely heavily on digital advertising, so the legal ruling from this case will indeed have a broader impact on them and how they have a digital media advertising strategy moving forward. Now let's shift our focus to user safety in digital media. One key debate is the balance between media and advertising standards versus free speech. X is arguing for more free speech, but advertisers ultimately decide where their ads appear, which gives them power over what content is published and promoted. This leads to another important question. Should social media platforms have control over what users post? If advertising standards dictate content moderation, it raises concerns about censorship and whether platforms truly are allowed to allow free speech for their users. Lastly, this case could have major financial consequences. Many digital media companies depend on advertising for their key revenue source. But if this lawsuit exposes GARM's monopoly, companies may rethink their business model and strategy and explore new ways to make money beyond just paid advertising.
Trade associations are vital to professional organizing, setting standards for professional conduct, and informing regulations. They may advocate for reform in government. They may also hold professional development opportunities for their members, and they can hold certification programs and set requirements for membership in the organization. Generally, they're nonprofit organizations, and they must follow state and federal laws in the locale where they're organized. These include requirements for association, as well as financial disclosures, non-discrimination requirements, and antitrust regulations. There have been several antitrust cases at the federal level, and federal courts have upheld that trade associations can, on some level, be held responsible for the actions of their member associations if their regulations in some way restricted trade. The legal guidance taken from a law firm has been that program restrictions should be, to the greatest extent possible, narrowly drawn, non-discriminatory, objective, fully articulated, and uniformly applied. Basically, to avoid antitrust violations, organizational requirements need to be as fair as possible, and they need to create an environment where everyone can compete fairly. While not to be litigated in court, there are obvious socio-political considerations with this case. Elon Musk, the infamous celebrity CEO of Twitter/X since late 2022, is a very polarizing figure. And in the shifting socio-political landscape, his leadership of Twitter and other organizations which he's CEO of has been rife with controversy. His decisions to cut safety as well as his decisions to shift the platform's operations have in and of themselves been controversial, but one could also argue that some of these decisions for advertisers to boycott the platform has been a result of, frankly, Elon Musk, his personality, and his politics. And you could also make the argument that their boycott of the platform is a retaliation directly towards Musk. However, what the case will litigate is whether this is individual corporate actions or collective corporate action.
Conclusion. The Sherman Act plays a critical role in this case. Section 1 of the Sherman Act states that every contract, combination in the form of trust or otherwise, or conspiracy in restraint of trade or commerce among the several states or with foreign nations is hereby declared to be illegal. This case revolves around Section 1 of the Sherman Act, which prohibits agreement that restrain trade. Corp claims that major advertisers, including Mars, CVS Health, and Orsted, coordinated a boycott to unlawfully restrict competition. However, these companies aren't direct competitors. They operate in different industries and serve different customers. Their only common ground is that they purchase ad space, which raises a critical question. Did they truly orchestrate a collective boycott, or were these independent business decisions? To prove an illegal boycott, Corp must show more than just similar timing of ad withdrawals. Courts require clear evidence of an explicit agreement, not just companies making similar moves. The advertisers argue they acted independently, citing brand safety concerns rather than a coordinated effort to harm Corp. This is a major hurdle for Corp because under antitrust laws, parallel business decisions aren't enough. There must be proof of collusion with an anti-competitive intent. Additionally, while these companies are part of the World Federation of Advertisers, WFA, and GARM, they don't actually compete with each other in the traditional sense. A candy company, a pharmacy chain, a renewable energy firm don't share a customer base. So even if coordination happened within these groups, does it fit the legal definition of an unlawful agreement to restrict trade? That's the key question the court must decide. So does participation in an industry group like GARM expose companies to antitrust liability? Possibly, if Corp can prove that GARM was used as a tool to coordinate and enforce a collective withdrawal of ads. Trade groups have been held liable in the past when they facilitated collusion. For example, American Society of Mechanical Engineers versus Hydro Level. However, merely being a member of GARM isn't illegal. The key issue is whether the group's activities cross the line into restricting competition. Ultimately, this case could set a precedent for corporate collaboration in antitrust law. If Corp wins, companies may need to be more cautious about how they participate in industry-wide discussions, particularly in organizations like GARM.